We're so glad to be here with you tonight, and so privileged to have Professor Barnett joining us from Georgetown. And instead of giving you a long introduction that just takes away from his time, I'm going to go straight into a question. When I was speaking to the Fellows Program yesterday, I mentioned that you started your, at least we'll call it your Supreme Court career with an interesting case. And I think it's so funny because when people think about you, they think, who knows what, but they think a lot of things. But I don't think they would think your first case, you argued against the Attorney General, Gonzalez, who was our guest last year, that you represented a property rights issue that involved personal growth marijuana on a California farm. I don't think that's what they would expect. So tell us just a little bit about how Gonzalez v. Raich changed your life.
Well, first of all, I just want to say thank you for inviting me to be here as a Florida resident, a very proud Florida resident. I live in Sarasota, Florida. I was also the proud possessor of 28 inches of seawater in my house during Hurricane Helene. So now we're somewhat dispossessed. But anyway, it's a great pleasure to be here and to be a resident of the state of Florida. I proudly show my Florida driver's license and my Florida concealed carry permit to whoever will ever look at it. So anyway, I know, constitutional carry, but I just prefer to have the permit. So the Raich case, I was a criminal prosecutor in Chicago. When I talk to judges and lawyers, I always want to start off by pointing out the fact that I was a trial lawyer, trying jury trials in Chicago, murder cases, the whole lot, just to show that I really was a real lawyer before I was an intellectual as a law professor. Oh yeah, there you go. That's me. That was, my goodness. That was me assigned to the felony review unit, which was a 24-hour, you used 12 hours on, 12 hours off. We had to review all. No felony could be charged in the city of Chicago without the approval of a state's attorney. And so there had to be a 24-hour available unit to go to police stations, respond, and evaluate cases. So that 6 months or 9 months I spent on that unit was probably the most interesting part of my job as a Cook County State's Attorney. It's really the heart of my next book called Felony Review, Tales of True Crime and Corruption in Chicago, which I just finished writing New Year's Eve. At any rate, I hadn't done any legal practice from that time afterwards. And so for a 20-year period, I considered myself a scholar and not a practicing lawyer. But I got involved in the medical marijuana cases because the trial judge in a different case involving the Oakland Cannabis Buyers Cooperative, who was Charles Breyer, Justice Breyer's brother, asked the parties to brief the Ninth Amendment. It was a Commerce Clause case, but they wanted him to brief the Ninth Amendment. Now, I'm sure all of you have memorized the Ninth Amendment because I'm sure it comes up in your practice all the time. For those of you who haven't memorized it, it says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And so Charles Breyer told the parties they wanted a briefing on the Ninth Amendment, so they went around the country to find anybody who knew anything about it, and it just so happened I was the nation's leading authority on this very obscure amendment, and they found me at Boston University, and so I got involved in the medical marijuana unit movement that way, that litigation. But the problem with that case was that in this cooperative, there was money and marijuana changing hands. You'd go in with money, you'd come out with marijuana. There is a word for that, the original meaning of commerce. That is the core of the original meaning of commerce. So it was kind of a challenging Commerce Clause claim when commerce is happening there. Now it's intrastate commerce, but anyway, my colleague Robert Raich in that case asked me if I thought it would be a good idea to bring a lawsuit in which no commerce was taking place, in which people were just growing it for their own use. And I said, yeah, I think that would be a very good idea. He said, would you be willing to be lead counsel in that case? And I said, sure. And so I became lead counsel in that case along with him, and his wife, Angel Raich, became our client, and another woman named Diane Monson, and that's how I got involved in this litigation. I did learn a lesson being involved in marijuana litigation, and that is you don't want your limo driver to be in the movement. Just you don't want that. They don't go to the right hotel, and they don't get there on time. Other than that, it's sweet. At any rate, so I ended up arguing that case in district court. I have to say I was the day I had to argue that case, I was actually very, very nervous. I had not actually been in court for 20 years. I had never argued an appellate court case or a constitutional case, and I had never clerked. So I was really, really nervous. But once I started, talking, and the judge started asking me questions, and I tell this story in the book. I try to emphasize bad things I've done, or weaknesses I have, or character flaws I have that have needed to overcome. So it doesn't all sound like roses. But anyway, we went from there to the circuit court, where we prevailed. Surprisingly, we had the two progressive judges rule for us. The one Reagan appointee ruled against us. I think there's a story behind that I tell in the book, but I won't tell it now why that happened. And then we got to Supreme Court, and I made my one and only Supreme Court appearance, and against Paul Clement. It was not his first argument. But I'll tell you one story about that, and then we'll move on. And that is, I was actually quite nervous building up to the case. The day of the argument, I was actually quite calm, but for 6 weeks before, I was nervous. And I got there, and Paul had to go first. And of course, as you know, you sit very, very close to the dais where you speak, and I was sitting directly next to him. And when he got up to speak in this case, which was a high-profile case, not as high-profile as other cases that came to be later, but it was a high-profile case, I saw his hand shaking like this. And nobody else would have seen that, but I was like sitting way closer than I am to you, Jamie, and that made me feel much, much better.
If he's nervous, then it was okay to be a little bit nervous,
exactly.
too. So you've been an attorney now for around 45 years. Is that fair to say?
Yeah.
How has the landscape of law changed in that time? And I'm going to say especially, let's say in the last 20 years, especially in the jurisprudence realm. And what reason do you have for that?
Well, two completely different things that have changed. And when I was a criminal prosecutor, prosecutors of any party thought their job was to prosecute crime. And that has become less true over time. I mean, at least in some jurisdictions, you have prosecutors who don't think their job is to prosecute crime. And we're learning, I think, firsthand what the consequences are of a failure to prosecute crime. And so that has changed. I think it may not be a permanent change as people experience how quickly you can kind of return to the state of nature if normal, ordinary, run-of-the-mill misdemeanors and felonies are not prosecuted. And so that's a change. Hopefully it's not going to continue in this direction. I think it probably won't. The other change on sort of the constitutional side is I think there's absolutely no question, and this starts at the Supreme Court on down, that judges now and justices now pay way more attention to the actual written Constitution than they used to. It used to be you could have many, many constitutional cases in which the text of the Constitution is not even mentioned. And in constitutional law, you might not even talk about the meaning of the text of the Constitution. You would focus single-mindedly on the meaning of a judicial opinion about the Constitution, not the Constitution itself. Not that those judicial opinions aren't absolutely essential. And in fact, when I teach constitutional law, I spend almost all of my time teaching judicial opinions. But I do mention the Constitution and the meaning that the text has and how that meaning should constrain what judges do on the bench. And so that's been a huge change. I think the one person most responsible for that change is the late Justice Scalia, with whom I have my disagreements, but he was an indefatigable champion for putting text moving text towards the center of constitutional decision-making, and the practice on the Supreme Court by all the justices, regardless of their political orientation or ideological priors, they all are way, way more attentive to the text than they used to be.
Rand Paul described you as a pioneering contrarian. which I think is a pretty good description for a libertarian in general. How would you describe what it means to be a libertarian? How would you describe how that philosophy came to be part of your nature, and what led to that over the course of your life? We can start with, I do know that this might have been the first indication. This is the 4th grade newspaper article written by Professor Barnett, which seemed to indicate where we were going in life pretty early.
Yeah. Well, I got my political principles from my father, who was my hero. My nickname for my dad when I was like 2 years old or 3 years old was Most Man, because that's what he was always. I actually was telling someone earlier, he was my #1 counselor throughout his entire life. When he got Alzheimer's and had a long period of decline, that was very, very difficult, since he was the person who I looked up to as my rock. And once your father passes, as many of you know, you sort of, now you're the head. Now who do you everybody comes to you for advice, but almost immediately my son kind of took over, and now he's my #1 advisor, because he's a lot more like my dad than I am, and so he's always the one that's telling me that I shouldn't be doing whatever it is I'm thinking about doing. So that's my son. That's my son's role now. So that's where I got my political principles from. He was a conservative Republican and a Goldwater type Republican. As the book describes, I debated on behalf of Barry Goldwater when I was 12 years old in front of my entire grade school and junior high school student body in a very working class Democratic town called Calumet City, south of Chicago. And I still have my debate notes, so I'm able to put in my summation, my 12-year-old summation for Barry Goldwater about, in your heart, you know he's right. So that's where it started, and I didn't consider. I thought myself as a conservative until I got to college, and I came across libertarianism, and then I considered myself a libertarian. I think I always was, and my dad, who never changed his opinion on anything because he was always right. And I'm not saying he thought he was always right. He actually was always right. He actually became a libertarian as well. And when I sort of told him what it was about, I do think, since we don't have too much time, we should move on to other topics. As somebody who became I'm not a Libertarian Party person. I want to be clear about that. But I am a small L libertarian. And I have been since college. I do think libertarianism itself is a political theory that needs substantial updating and refinement. It has somewhat been frozen in amber since the 1970s or 80s when I first became exposed to it. And no theory should be frozen in amber. Every theory, like originalism, for example, needs to develop and improve upon itself. And my next book, which I'm going to start as soon as I get this book about being a prosecutor put to rest, about a rethinking of libertarian first principles and how we should develop libertarianism for the real world, which I think is going to necessitate some refinement of what libertarians think of as first principles.
You talk a lot in your book.
I should say at the end of the book, I tease some of the ideas I have in mind here. There's a concluding chapter, What's Next? And there is a part of that chapter called What's Next for Libertarianism that sort of previews along these lines.
You spoke in your book about this proverb that it really struck me, that God writes straight and crooked lines. You followed a fairly non-traditional path to everything. You did not grow up in a way that would necessarily lead one to think, I'm going to go to Harvard Law School. You did not do the things at Harvard Law School that would lead one to think, I'm going to be a professor. And this was pretty much the story of your whole life and your career. Talk a little bit about that and what that meant to you and how you became a professor and that path as well.
Yeah, when I was in high school in Calumet City, my highest aspiration was to attend the University of Illinois, and I got my SAT scores. And I got a meeting with my guidance counselor. My guidance counselor said, well, scores like that, you could get into Northwestern. And I said, really? Where's that? For those of you who don't know, that's on the north side of Chicago. I'm on the south side of Chicago. That's on the north side. So it gives you an idea of the kind of, I didn't grow up in an academic home. My father was a small businessman. My mom was a stay-at-home mom until later on she became an interior designer. So I didn't know about that stuff. My parents knew about a lot of stuff. They just never told us about it. They were from Chicago. And so that was the first kind of startling thing. I didn't really care that much about the Ivy League, didn't know much about it. I thought they had I think they had football or something, but other than that, it didn't mean much to me. But then I got my LSAT scores and I applied, and sure enough, I got into Harvard Law School. It's the only reason I could have gotten in. And in those days, it was much more LSAT driven. And so I figured, the reason I went to Harvard Law School, my goal was to go to Northwestern Law School. My reason I went to Harvard, I thought, I plan to spend my entire life as a criminal lawyer in Chicago. And so I don't want to just stay in Chicago my whole life and never have left. So I wanted to, if I spend my whole life in Chicago, I want to go away first. So it's a choice that I stayed in Chicago. It wasn't inertia. And so I did actually go back and be a criminal lawyer. I just want to say I wanted to be a lawyer because of a television show that came on in 1962 called The Defenders, starring E.G. Marshall and Robert Reed as a father-son criminal defense team in New York, filmed on location. It was a very gritty show for its time, very realistic. Not about solving murders like Perry Mason was. That was not about being a lawyer. This was a show about being a lawyer. And that made me want to be a lawyer. And to me, what being a lawyer meant was be a criminal lawyer. That was it.
I think it'd be interesting. I think there's probably a lot of us who decided to be lawyers based on TV shows. Mine was not that one, though. Talking about law school, and you've been a professor now for a number of years, just moving to the current, what is your thought on sort of freedom of thought in law school, the debate between students? Are they able to engage in open debate? Is there discussion in law school classrooms now? What have been your observations?
Well, I don't want to be. I have a very good experience at Georgetown. I have not had any bad experiences at Georgetown along these lines at all. But I did in order to become a resident of the state of Florida, I bought out my third course, which means I no longer have to teach in this semester, which is why I can live here. When I had to drop a course, the course I dropped was my required Con Law 1 class, which was a relatively small section. I now teach the elective Con Law 2 class, which is rights. Con Law 1 is structure, Con Law 2 is rights. And I teach my seminar, Recent Books on the Constitution. And that means the only students that take me are the ones that want to take me. And that includes a lot of people who are right of center and left of center, but they're all people who know me by reputation and want to hear what I have to say, and they're fantastic. So I've got no problem, but I think if I were teaching a required course, there's a possibility people might object to hearing from me or being forced to hear from me. But again, that has not been my experience, in part because post-COVID, I haven't been teaching required courses.
When you first decided to embrace the buttons do not work. When you first decided to embrace originalism as a legal philosophy, you've talked about it. It's kind of the basis of the classes you teach. It's the basis of how you teach. It's the basis of your books. You've written numerous books on this. Why do you think why that appealed to you? Why was that kind of where you went? But why do you think it's important? Why should anyone in this room know about it? Why should we care? Why is it important that the public cares, the non-lawyers, the non-judges? Why is this even a thing that should be on anyone's radar? Why do you spend New Year's Eve writing books? I think is really what we want to know.
Well, has everybody here heard of originalism? You've heard the word?
Assume they have
originalism. Originalism can be summarized in a single sentence. The meaning of the Constitution should remain the same until it's properly changed by amendment. That's all originalism is. The meaning of the Constitution should remain the same until it's properly changed by amendment. And I went to law school believing in the Constitution. I took constitutional law in my second year as a required course at Harvard from Larry Tribe, was my professor. And during that course, I read the Gunther casebook, and as I didn't know that much about the Constitution, and I was reading the casebook as a student, and I kept coming across good parts of the Constitution, like the Ninth Amendment. And I would read that, well, wow, that's amazing. Then I would turn the page of the casebook, and the Supreme Court would say, Well, that doesn't mean anything. In fact, what the Supreme Court actually did was confuse it with the 10th Amendment. That's how careful they were being. And then I would get to other things like the Commerce Clause, and that would mean everything, and the Second Amendment would mean nothing, and the Necessary and Proper Clause, that was a carte blanche to do anything you want. And really, I would get to, and I would read opinions like the Lochner case, which I happen to like, and I would turn the page, and I would say, no, you're supposed to hate the Lochner case. That's the worst thing you're supposed to do. So by the time I was done with the course, I was kind of done with con law. I was done with the Constitution itself, because my view was if the Supreme Court wasn't going to pay attention to what the Constitution says, why should I? And then I persevered, in my view, to be a criminal lawyer, because that was just non-existent. And when I became a law professor, being a con law professor was the last thing I expected to be. I was a contracts professor. I have a contracts casebook. I've written a lot about contracts, not so much lately, but I used to, because in contract law, law still mattered. The actual law of contracts was a sophisticated body of law, spent centuries being built up, and writings matter. What you say, now we understand there's ways around writings, but boy, oh boy, you'd rather have a clause that says what your client wants it to say than says the opposite, because the writing still matters. So that's what I was, and the book tells the story of how I got pulled into constitutional law sort of against my better judgment, and now that's really all I do. But that sort of led me to want to sort of play a role in letting the courts follow the Constitution again. Now that seems like a very grandiose objective, and if you'd asked me when I was in law school whether I would ever play a role in doing that, I would tell you you're going to have your head examined. But I became an originalist. This is the last thing that I think I need to talk about. I became an originalist in a very unique way. I was persuaded by the criticisms of originalism based on framers' intention. Then framers' intent was a misbegotten way to decide what the meaning of the Constitution was. It was not practical. You couldn't figure out what framers' intent was. And I was persuaded by that theory, by that argument, which was first formulated by Paul Brest in 1980, a critic of originalism who coined the term originalism. The term was coined by a critic of originalism, Paul Brest, who became the dean of Stanford Law School, in an article called The Misconceived Quest for Original Understanding. I was completely persuaded by that article. And then I was teaching a seminar at Boston University, and there was a footnote in one of the articles I was teaching it was called The Unconstitutionality of Slavery by a man named Lysander Spooner, published in 1845. Now, I knew from Lysander Spooner because he ended up being a radical libertarian in his later years, wrote some very radical tracts that I read, one in particular that I read in college. Otherwise, I knew nothing about him. And I thought, what could Lysander Spooner possibly have said in 1845 about the unconstitutionality of slavery? So I had the library get me whatever this was. It turns out it was a 280-page monograph. And what Spooner was doing in this book was responding to the radical abolitionists, who was William Lloyd Garrison, who was a newspaper editor, and his right-hand man was a lawyer named Wendell Phillips, student of Joseph Story. And what the radical abolitionists had argued was the Constitution was a covenant with death and an agreement with hell, because it sanctioned slavery. And at their protests, at their demonstrations, they would burn copies of the Constitution, which made them very unpopular. And it's the reason why many anti-slavery activists refused to call themselves abolitionists, because they didn't want to be associated with the people that burned the Constitution, because Americans like the Constitution, generally speaking. But when the Madison Papers were published for the first time, these are Madison's notes that are kept secret for 50 years. When they get published in 1840, the Garrisonians mined those notes for all the evidence that the intentions of the framers was to protect slavery or to make compromises of slavery, and there were those fights in the Philadelphia Convention, and there were advocates of slavery in the Philadelphia Convention, and there were opponents of slavery in the Philadelphia Convention, and they mined that, and Wendell Phillips published a book called The Constitution, a Pro-Slavery Compact. And Spooner's book was a response to Phillips' book. Spooner wrote 2 years later, The Unconstitutionality of Slavery. And what Spooner argued was, we don't have to pay any attention to the intentions of the framers. The intentions of the framers are their own business. Whatever they may have intended in Philadelphia is their own business. That is not what binds us. That is not the law. The law are the words they produced. The law is the text. And what Spooner said was the law was the original meaning of the Constitution. And if you look at all the provisions that are supposedly the slave provisions, none of them use the word slave. They use euphemisms, persons held to service, or they refer to refer to enslaved people as persons in all those things. And he said, we're not bound by the guilty meaning. We're not bound by the evil meaning that's been placed upon those words. In practice, we're only bound by the innocent meaning those words can have, because after all, they were all, I would say now, they were all euphemisms. A euphemism is a good word that you say instead of saying a bad word. And so I'm reading this thing, and I'm thinking, now this is a version of originalism I can do something with. I'm a legal scholar. I'm a legal theory guy. That's my job. And this is a theory I'd never heard of before. I'll bet you there's an originalism, there's a version of originalism that would be immune from the criticisms that had properly been made against the original intent version of originalism, which is the one that Robert Bork, for example, had enunciated in his writings. And so that's what I started to pursue. And by 1999, I had become persuaded that that was the right way to approach the Constitution, to take the Constitution seriously. Unbeknownst to me, because I didn't run in those circles, Antonin Scalia, who was then a circuit court judge, had come to the same conclusion for completely different reasons. He was a legislation guy, and he thought statutes should be interpreted this way, and so therefore so should the Constitution. And he was telling people in the Mies Justice Department, they were having seminars there during Ronald Reagan's second term, that they should forget about this framers' intent stuff and focus on original meaning. So that when my theoretical scholarship came out, beginning with my book, Restoring the Lost Constitution in 2004, arguing for original meaning, by this time I had discovered, some people had told me, that Judge Scalia, now Justice Scalia, he had made the same move, and that I provided sort of the theory for which he was going around the country in his indefatigable way defending the practice of adhering to the meaning of the text, and saying that judges are all, and all constitutional authorities are bound by the meaning of the text, because the meaning of the text should remain the same until it's properly changed by amendment.
Well, I know the chief would like us to continue all night on this, especially bringing up your very memorable tweets on, well, X, formerly known as Twitter, or whatever we call it now, which is popular both with the chief and with my husband, Josh Grosshans. So I get fairly regular things, including about, evidently, you really dislike Oliver Wendell Holmes Jr. But rather than go into this, which is highly controversial, you can tell the chief later your opinion on this. Tell me, when you look back, you've written this book, you've done some amazing things. You've met amazing people. You've interacted. You've had conversations with some of the most brilliant minds. You have taught. What is the accomplishment you're most proud of?
Well, I can tell you that this is not my accomplishment I'm most proud of. I'll tell you my accomplishment I'm most proud of, but first I'll tell you the thing that was the most fun thing I ever got to do that I never expected to do when I was as a law professor, and that is I got to be in a feature film. I got to be in a science fiction movie.
I did not see this answer coming. I did not see this one.
Portraying a prosecutor in a science fiction film called Inalienable. And it was the last third of the movie, this bizarre, somewhat bizarre science fiction movie. The last third of the movie is a courtroom drama. And I got to play a prosecutor, which meant, and all the actors in this movie were sci-fi actors from TV. It was written by Walter Koenig, who played Chekhov in the original Star Trek. The person who played the prosecutor that I was the assistant to was Marina Sirtis, who played Counselor Deanna Troi on Star Trek Next Generation. So I spent 4 days on a movie set.
We have hit a level of nerdhood that is beyond where I expected we were going.
I spent 4 days on a movie set playing a lawyer. I would come off the set, and other actors there, I wasn't an actor, all the actors would come up to me because they assumed I was an actor, and they said, "Boy, you really look like a prosecutor in there." So that was the highlight. That was one of my. I have a reverse bucket list. There's things I never thought I would ever do, but after I do them, I thought, well, if I had a bucket list, I would put that on there. And this is one of them. Now, I just want to say, you can watch this movie for free. You can pay $4 to watch it on Amazon, or you can watch it for free. It's on YouTube. Just Google "Inalienable the movie." The movie will come up on Amazon, on YouTube. But I have to warn you, it is not the best movie that has ever been made. It is, however, the best movie that's ever been made that I'm in. So the accomplishment I'm most proud of is raising 2 great kids and now 5 grandkids, and so that is my biggest accomplishment. And both my kids are my advisors. My son is my dad, and my daughter is her own person, and they both give me advice that I always follow because they're usually right. And so that's my proudest achievement. But as an academic, it's my writing. I'm not one of these professors who I said, well, how much do I have to write to get tenure? If I only met the minimum requirement to get tenure, I'd leave the business, because that means I was in the wrong line of work. I like writing, and I'll tell you why. I don't write to tell people what to think. I write to discover what I think, because I don't really know what I think for sure by just thinking about it. I have to work it out, and things are too complicated to keep in your head, so you have to put something down, and then you have to ruminate on that, and then add more and add more. And so I write for what I think, and my goal is to make the world a better place. And I think that the one way that's within your power to make the world a better place is to contribute to the store of human knowledge. And that's something you can do on your own without anybody agreeing with you. All you have to do is publish it. And someday, sometime, like, you might run across a book that was written in 1845 by a man named Lysander Spooner, who was otherwise very, very obscure, famous to some people, but not that many. And that book might change someone else's life, the way it changed my life. So maybe if you just put your knowledge on paper, that can happen to you. You'll never know. You won't be around when it happens, but, that might make the world a better place.
Well, thank you, Professor Barnett. We're very glad you're a Floridian now.